Greetings to the students, my name is David, and in the following presentation I will talk about the criminal law of the United States, because it is important for us to see the differences between civil law countries and Anglo-Saxon countries, and what are the differences in the criminal law system in general. So first, some introduction about the structure of the American criminal law, the source and forms of law. In the 18th century, English criminal law was generally uncodified. This common law was developed by and embodied in judicial opinions. The American colonies adopted the common law of England as it existed at the top of American independence. The period most popular treatise, William Blackstone's Commentaries on the Laws of England, became a highly influential work in America, not because of anything particularly distinguished about the 4 volumes, but simply because its popularity coincided with American independence. Volume 4 provided a useful summary of the then existing body of common law criminal jurisprudence. American courts then took on the role of further refining and developing the law, thereby creating differences with English law. Today's courts generally no longer have the role of refining and developing the criminal law. That function has been taken over by legislatures. Nearly every state has a criminal code as its primary source of criminal law. Courts interpret the code but generally have no authority to create new crimes or change the definition of existing crimes. The reasons for the shift from common law judicially defined offenses to criminal codes are found chiefly in the rationales offered support of what is called the legality principle. This will be discussed later. Then about the modern criminal code reform. Although there were some heroic efforts, little criminal code reform occurred in the United States before the 1960s. Most early codes were less a code and more a collection of ad hoc statutory enactments, each triggered by a crime or a crime problem that gained significant public interest for a time. The major contribution of early codifiers frequently was to put the offenses in alphabetical order. The greatest catalyst of modern American criminal law codification was the Model Penal Code, which was promulgated by the American Law Institute (ALI) in 1962. Since its introduction, the Model Penal Code has served as the basis for wholesale replacement for existing criminal codes in almost 3/4 of the states. Some states adopted the code with only minor revisions, while others, especially those that adopted it early, borrowed the Model Penal Code style and formed but only some of its content in the course of reworking their existing doctrine. So about the Model Penal Code, the American Law Institute, which drafted the Model Code, is a non-governmental, broad-based and highly regarded group of lawyers, judges, professors and others that undertakes research and drafting projects designed to bring rationality and enlightenment to American law. The Institute's restatements of the law have been influential in bringing clarity and uniformity to many fields such as tort law and contract law. Although a criminal law project was undertaken by the Institute in 1953, it was concluded that the criminal law of the various states had become too disparate to permit a restatement, and in any case the existing law was too unsound and ill considered to merit restating. What was needed instead was a model criminal code. After 9 years of work and series of tentative drafts, the Institute approved an official draft in 1962. Later, the original commentary contained in the various tentative drafts was consolidated, revised, and finally in 1985 published along with the 1962 text as a 6-volume set. There were continuing reform efforts. About 1/4 of the states have not yet adopted a modern criminal code. The federal system is the most unfortunate example of frustrated reform. Congress has been engaged in an effort to reform the federal criminal code since 1966, but at one point a modern code bill passed in the Senate but did not pass in the House. Criminal code reform is always difficult because it touches highly political issues, but the lack of a modern federal criminal code is a matter of some embarrassment in a country whose states lead the world in enlightened criminal law codification. The present federal criminal code is not significantly different in form of the alphabetical listings of the offenses that was typical of the original American codes in the 1800s. Fortunately, the U.S. Constitution vests the criminal power in the states, not in the federal government, which has jurisdiction over only uniquely federal offenses. Let's look at the central features of modern American codes. Modern American codes stand apart from many other modern codes because they are designed to include a comprehensive and self-contained statement of all rules required to adjudicate all criminal cases. They try not to depend on other sources of law, academic or judicial. Modern codes have a general part containing general provisions that apply to the specific offenses defined in the code's special part. General provisions include such things as general rules for the definition and interpretation of offenses, a collection of definitions for commonly used terms, general liability, doctrines concerning omission liability, complicity, involuntary intoxication, and general defenses such as self-defense, insanity, and time limitations. In the special part of a code, offenses are defined and organized as conceptually related groups and are formulated and consolidated to minimize overlaps among offenses and gaps between them. A significant practical effect of reform is that code sections can no longer be read in isolation. To fully understand each offense definition in the special part, several provisions in the general part must be consulted. So again, if we look at the civil law countries and the United States criminal law, they are getting closer and closer. They are very similar. They have criminal codes. They have both general part and special part, and the structures are very similar as well, all in all. Okay, now next let's look at the legality principle. In its original Latin dress, the legality principle was expressed as nulum crimen sine lega, nulla pena sine lega, meaning roughly no crime without law, nor punishment without law. In its modern form, it means that criminal liability and punishment can be based only on a prior legislative enactment of liability rules, expressed with the adequate precision and clarity. The principle is not itself a legal rule, but rather a legal concept embodied in a series of legal rules and doctrines. So first, the legality doctrines. Two of the doctrines that make up the legality principle include the rules in modern American criminal codes that abolish criminal law crimes and prohibit the judicial creation of offenses. In contrast, in 1962, the English House of Lords approved prosecution of common law offense of conspiracy to corrupt public morals. American jurisdictions typically would bar prosecution for such an uncodified offense because it is undefined by statute. In addition, the legality principle is embodied in the constitutional prohibition of vague statutes, the rule requiring strict construction of penal statutes, and the constitutional prohibition of application of ex post facto laws. The vagueness prohibition, rooted in the Constitution's due process clause, requires that a criminal law statute give sufficient warning that men may conform their conduct so as to avoid that which is forbidden. A statute is not unconstitutionally vague, however, merely because one of its elements calls for a matter of judgment. Rather, an offense provision is vague if it does not adequately define the prohibited conduct. If an offense definition defines the prohibited conduct with some specificity, but is subject to two or more interpretations, then it is termed ambiguous, which is not necessarily unconstitutional. When faced with an ambiguity, the law traditionally applies a special rule for interpreting criminal statutes. The rule of strict construction, as it's called, directs that ambiguity in a penal statute be resolved against the state and in favor of the defendant. For this reason, it is also called the rule of lenity. One final legality doctrine is the constitutional prohibition against ex post facto laws. Again, ex post facto. This has been interpreted to invalidate every law that makes an action done before the passing of the law and which was innocent when done, criminal and punishes such action. Every law that aggravates a crime or makes it greater than it was when committed. Every law that changes the punishment and inflicts a greater punishment than the law annexed to the crime when committed. Legality principle rationales. The American devotion to the legality principle arises from rationales unrelated to and often in conflict with blameworthiness. Although not all the rationales may be applicable in all situations, the rationales most commonly offered in support of the legality principle include the following. First, procedural fairness. Fairness requires that a person have at least an opportunity to find out what the criminal law commands. Actual notice is not required for liability. It is enough that the prohibition has been lawfully enacted. Similarly, a defendant's actual knowledge that the conduct is prohibited and punished does not vitiate a legality-based defense. The concern of the legality principle is procedural fairness, not blamelessness. Okay, the second is criminalization as a legislative function. In a democracy, that the legislature, the most representative branch of government, is generally thought to be the proper body to exercise the criminalization decision. This rationale directly supports the prohibition of judicial creation of offenses and the abolition of judicial created offenses. So they are against the judge-made law concept. It also has application in less obvious ways to support the invalidation of vague statutes and the disapproval of ambiguous statutes. Courts applying such statutes provide the specificity that legislature has not a de facto delegation of criminalization authority to the courts. The third one, rules of conduct and principles of adjudication. The rationales noted so far, procedural fairness and reserving the criminalization function to the legislature, concern the rule articulation function of the criminal law, understood as its obligation to communicate the governing rules to all members of society. The rationale reflect the American preference for how the rule articulation function ought to be performed. The legislature should set the rules, and the formulations should be calculated to give adequate notice to deter effectively and properly, and to condemn a violation fairly. But criminal law also serves an adjudication function, with which several rationales in support of legality principle are associated. Fourth one is inconsistency and abuse of discretion. Consistency in treatment of similar cases is possible only with sufficiently clear and precise definition of an offense, one that does not call for discretionary judgments. With individual discretion, inevitably comes disparity based on the inherent differences among decision makers. Also, the exercise of discretion can allow the operation of malevolent influences such as racism, sexism, and the like. An unclear prohibition, therefore, can create a potential for abuse of discretion by police officers, prosecutors, and others with decision-making authority. In Peppa Cristo versus City of Jacksonville, for example, police officers arrested mixed couples of blacks and whites, charging them with a variety of vague offenses such as vagrancy, loitering, and disorderly loitering on the street. The Supreme Court reversed the convictions, finding that the vagueness of the statute encouraged arbitrary convictions as well as arbitrary arrests. Okay, next part, we talk about the brief summary of the American criminal justice process. The authority to define and punish crimes is vested primarily in the states, not in the federal government, except for offenses relating to special federal interest. Thus, there are 52 American criminal justice systems, including the Federal and District of Columbia, and each is different from the others in some way. So let's look at the most typical forms of these criminal justice systems. Okay, first subpart, investigation and accusation. And first, report and investigation. The criminal justice process usually begins with a report of a crime by a citizen or a police officer. Typically, an investigation follows to determine whether a crime has in fact been committed, and if so, by whom. Once a suspect has been identified, the investigation may continue in order to collect evidence for use in prosecution. Second, arrest and booking. When a police officer believes that there exists probable cause to think that a crime was committed and that a particular suspect committed it, the officer may arrest that suspect. Sometimes the evidence is presented to magistrate beforehand and a judicial warrant to arrest is obtained, but most arrests are made without a warrant. An arrest is essentially a taking of physical control over the person and usually includes a search of the person for weapons, contraband, and evidence relating to the crime. The arrestee is then taken to the police station where he or she is booked. This procedure consists of entering the arrestee's name, the time, and the offense changed in the police log. The arrestee is photographed and fingerprinted, informed of the charge, and allowed to make a telephone call. Those charged with minor offenses are allowed to post cash security as station house bail, which allows them to leave the police station with a promise to appear before a magistrate at a specified date. Persons who are arrested for more serious offenses or who are unable to post situation house bail are sent to lockup after another more careful search, including an inventory of their personal possessions. Pre-charge screening. The first of many reviews of the charging decision is frequently made at this point. A higher-ranking police officer may reduce or drop the charges for which a suspect was booked. This may occur either because the evidence is insufficient to proceed or because an informal disposition, perhaps including a lecture and warning, is more appropriate. 10 to 20% of all cases are dropped from the system at this point. A member of the prosecutor's office also may screen the cases during this stage, although this frequently occurs only in felony cases. Initial appearance. Soon after a person is arrested and booked, unless released on station house bail, he or she is brought before a magistrate. The magistrate confirms that the arrestee is the person named in the complaint and informs the arrestee of his or her constitutional rights, including the right to remain silent, the right to have counsel, and the right to have counsel appointed if he or she cannot afford one. Frequently, counsel is appointed at this stage. Next one is bail. The magistrate at the initial appearance also reviews any bail conditions, previously sat at the station house and sets bail for those arrestees who did not previously have it set. High bail amounts typically require the services of professional bonds meant to ensure the defendant's appearance, to whom the defendant must pay a non-refundable or only partially refundable fee. Increasingly, defendants have been allowed to pay in cash an amount equal to 10% of the total bail amount, which is then refundable if the defendant appears as directed. Okay, the next one is the pre-trial phase, and within that preliminary hearing. For felony cases, another judicial screening decision is made within a week or two of the initial appearance. Unlike the ex parte review at the complaint stage, this screening involves an adversarial process where the prosecution prevents witnesses and the defendants, now represented by counsel, and may cross-examine. The defendant may present his or her own evidence, but in practice rarely does so, preferring instead to learn as much as possible about the prosecution case without divulging in his or her own defense. The magistrate may dismiss the charges or may allow only a lesser charge than the alleged in the complaint. Okay, next, the grand jury indictment and prosecutorial information. Another screening stage for felonies is grand jury review to determine whether an indictment should be returned against the defendant. The federal justice system and about half the states give felony defendants a right to grand jury review. A grand jury is made of citizens who are called to meet regularly to review cases during a set term of perhaps several months. The traditional size is 23 people, of whom a majority of 12 must agree in order to indict the defendant. This majority corresponds to the standard size of trial jury. The grand jury procedure is significantly different from trial and from the preliminary hearing. It is in fact more akin to a magistrate's review of complaint. Only the prosecution presents witnesses and the hearing is held in secret. The defendant has no right to be present. Okay, next is the arraignment. If the defendant is indicted by the grand jury, the indictment substitutes for the complaint as the formal charging document. The defendant is arraigned in the general trial court on this document and is asked to plead guilty, not guilty, or where permitted, nolo contendere. A date is then set to hear pre-trial and trial matters. Fourth one is plea bargaining. From the point of filing the complaint and sometimes before until trial, the defense counsel and prosecutor may engage in plea negotiations. This may involve either an agreement to dismiss some charges if the defendant will plead guilty to others, or, in some jurisdictions, a promise of a lenient sentence or a recommendation for one in exchange for a plea of guilty. Challenges to the constitution of the prosecution, such as challenging the makeup of the grand jury or the sufficiency of the charging instrument, as well as requests for discovery and motions to suppress evidence, typically are made before trial. These motions may produce a dismissal for a defendant without the need of a plea bargain. Okay, the next big phase is the trial and the post-trial. The trial. After the defendant has been arrested and charged with a crime, if there has not been a dismissal and the defendant has not entered a guilty plea, the case goes to trial. Severity distinguish the American criminal systems from civil systems. These include the presumption of the defendant's innocence, the requirement of proof beyond reasonable doubt, the right of the defendant not to take the stand, the exclusion of evidence obtained by the state in an illegal manner, the more frequent use of incriminating statements of defendants as evidence. An American trial uses an adversarial process. The defendant is represented by an advocate representing his or her position, while the state's prosecutors represent the state's interest in punishing offenders. The sides argue in front of an impartial decision maker. In all 52 jurisdictions, the defendant has a right to jury for all felony offenses and for misdemeanors, punishable by more than 6 months imprisonment. Most states also provide a jury trial for lesser misdemeanors as well. The right to jury trial can be waived in favor of a bench trial. Okay, next is sentencing. If a defendant is convicted at a trial or pleads guilty before a trial takes place, the court will set a date for a sentencing hearing, at which both sides will present evidence relating to the appropriate sentence. While a few jurisdictions allow for sentencing by a jury in non-capital cases, most assign the sentence determination to the court. Typically, three different types of sanctions can be used: financial sanctions, some form of release into community, for example probation or house arrest, and lastly an incarceration in a jail for lesser sentences or a prison for longer sentences. The most severe form of punishment is the death penalty, the availability of which is determined by each individual state. The legislature typically sets the maximum penalty available for an offense. It sometimes also narrows the sentencing option for an offense by excluding community release or by setting a mandatory minimum term of imprisonment. Increasingly, court sentencing decisions are restricted by guidelines that suggest a guideline sentence for offenders of a particular sort committing offenses of a particular sort. Some guideline systems are more binding than others. Appeal. A defendant generally has a right to appeal a conviction to the next higher court in the particular system judicial hierarchy. For the misdemeanors tried in the magistrate court, this may mean a new trial in the general trial court. The right to appeal is not necessarily limited to those convicted at trial. However, a defendant who pleads guilty but who receives a more severe sentence than he or she expected, for example, may be able to appeal challenging his or her plea. Appellate review of the appropriateness of the sentence is generally not permitted, although review of deviation from sentencing guidelines may be. The most common objections on appeal concern admission of evidence claimed to be improperly obtained. Insufficient evidence to support the conviction, incompetent counsel, improper identification procedures, and improper admissions of the defendant's confession or incriminating statements. Lastly, post-conviction remedies. After exhausting possibilities for appellate review, a convict who has not gained release may seek relief through post-conviction remedies, sometimes called collateral attacks on conviction. Sometimes this is done through the writ of habeas corpus, but it is commonly governed by a more modern statutory procedure. After exhausting post-conviction remedies in state court, state prisoners who have a constitutional claim may present the same claim for review by federal court under federal post-convictions remedy procedures. In both state and federal systems, the process of appellate review of denial of a post-conviction petition follows the same appellate course than the direct appeal did. Okay, after this I would like to show you an exact example from a TV show, which obviously is not entirely exactly the same as in real life, but very close to it, and you can have a good picture of the American criminal procedures. Okay, next big part is liability requirements. Offense definitions are typically made up of three kinds of objective elements: conduct, circumstance, and result elements, each accompanied by corresponding culpability requirement of purpose, knowledge, recklessness, or negligence. Some doctrines will allow a defendant to be treated as if he or she satisfies a required element that is not in fact present, if the defendant does satisfy the requirements of a doctrine of imputation. For example, a defendant may be liable for an offense that requires conduct that the defendant did not commit if the conduct performed by another person is imputed to the defendant by the complicity doctrine. Finally, a defendant who is apprehended or stops before completing an offense may be held liable for an inchoate offense on the basis of his or her intention to commit or encourage the conduct toward the commission. First, objective offense requirements. Offense definitions consist of two kinds of elements: objective elements, again, conduct, circumstance, or result elements, and culpability elements, typically purpose, knowledge, recklessness, or negligence. Each objective offense element has a corresponding culpability element, and the culpability level may be different with respect to different objective elements of the same offense. Okay, first, conduct, circumstance, and result elements. The Model Penal Codes chapter constructed a useful system for precise definition of offenses, defining elements of an offense, distinguishing between conduct, attendant circumstances, and the result of conduct. These are the objective building blocks for offense definitions. Each offense definition typically has at least one conduct element which satisfies the act requirement inherent in all criminal offenses. Most offense definitions include one or more circumstance elements, as well defining the precise nature of prohibited conduct. For example, having intercourse with a person under 14 years old, or the characteristics of a prohibited result, for example, causing the death of another human being. A minority of offenses containing a result element. Homicide offenses, personal injury offenses, and property destruction offenses are examples of this minority of offenses. They require resulting physical harm in order to sustain a conviction for the offense. Other offenses, such as endangerment, indecent exposure, and falsification, may require the person to cause risk harm or to cause an intangible harm, such as alarm or false impression. Okay, second is causation requirement. Whenever an offense definition includes a result element, for example, homicide requires death as a result, a causation requirement is also implied, which is similar to the Hungarian concept as well. That is, it must be shown that person conduct caused the prohibited result. This required relation between the defendant's conduct and the result derives from American notions of causal accountability. The rules of the causation doctrines are the means by which the law attempts to define the conditions under which such causal accountability exists. Requirements of causation. Establishing a causal connection between a defendant's conduct and the result typically has two independent requirements. First, the conduct must be a but-for cause for the result. That is, in the language of Model Penal Code section, the conduct must be an antecedent but for which the result in question would not have occurred. This is sometimes called the factual case requirement. Second, the strength and nature of the causal connection between the conduct and the result must be sufficient. Legal cause, or proximate cause as it is sometimes called, requires that the resulting harm not too remote or accidental in its occurrence to have a just bearing on the actor's liability or on the gravity of his offense. This language from the modern penal code is sometimes supplemented by an additional requirement that the resulting harm not to be dependent on others' volitional act. Next is factual cause. Conduct is a factual cause of a result if the result would not have occurred but for the conduct. In other words, the conduct is a factual cause if it was necessary for the result to occur. The factual cause inquiry is essentially a scientific and hypothetical one. It asks what the world would have been like had the defendant not performed his or her conduct. Specifically, would the result still have occurred when it did? If the answer is no, then the defendant's conduct was necessary for and thus was a but-for cause of the result. Further is proximate legal cause. In contrast to the scientific inquiry of the factual cause requirement, the proximate legal cause requirement presents essentially a normative inquiry, deciding whether a result too remote or accidental in its occurrence, or too dependent on another's volitional act, obviously calls for an exercise intuitive judgment. The inquiry cannot be resolved by examining the facts more closely or having scientific experts analyze the situation. Ultimately, the decision maker must determine how much remoteness is too remote or how much dependence on another's volitional act is too dependent for the result to have a just bearing on the defendant's liability. Typically, the foreseeability of the result following from the defendant's conduct is a highly influential factor in the determination of proximate cause. Next big side of the offense is the culpability requirements. Modern American courts typically follow the Model Penal Code section in providing that a person is not guilty of an offense unless he acted purposely, knowingly, recklessly, or negligently, as the law may require, with respect to each material element of the offense. This provision reflects the criminal law's commitment to requiring not only a breach of society's objective rule of conduct, but also defendant's culpability with regard to conditions that make the conduct a breach. A defendant's conduct may be harmful to the victims, may have a claim in tort and fairness and utility. Both may suggest that the defendant rather than the victim should bear the loss for the injury, but without culpability in the defendant causing the injury may be seen as lacking sufficient blameworthiness to deserve the condemnation and reprobation of criminal conviction. Shift to element analysis. Model Penal Code section makes clear that the code requires culpability with respect to each material element of the offense. In other words, it is not just that the different offenses may have different culpability requirements. With this section, the Model Penal Code makes clear that different objective elements within a single offense may have different culpability requirements than all or some of the other objective elements of the offense. Culpability levels under the Model Penal Code. In place of plethora of common law, terms wantonly, heedlessly, maliciously, and so on, the code defines 4 levels of culpability: purposely, knowingly, recklessly, and negligently. Ideally, all offenses are defined by designating one of these 4 levels of culpability with regard to each objective element. If the objective elements of an offense require that a person take the property of another, the culpability elements might require, for example, that the person know that he or she is taking property and that he or she be at least reckless about it being someone else's property. And offense also may require culpability with regard to a circumstance or result beyond what the objective elements of the offense require. Thus, theft may require purpose to permanently deprive the owner of his or her property, although it need to be shown that owner was permanently deprived. Purpose. Under the code, a person acts purposely with respect to a result of his or her conscious object its cause to such a result. This is a demanding requirement that is often difficult to prove. The offense of indecent exposure, for example, requires more than showing the defendant exposed himself or herself to another, knowing that it would alarm the person. It must be proved that the conduct was motivated by a desire to gain sexual gratification or arousal by the conduct. Doing it just to annoy or alarm the victim would not satisfy the offense gratification purpose requirement, even if the offender did experience unplanned for gratification. Purposely versus knowingly. A person acts purposely with respect to a result if it is his or her conscious object to cause the result. A person acts knowingly with respect to a result if it is not his or her conscious object, but he or she is practically certain that the conduct will cause that result. An anti-war activist who sets a bomb to destroy a draft board's offices may be practically certain that the bomb will kill the night watchman, but may wish that the watchman would go on a coffee break so that he would not be killed. The essence of the narrow distinction between these two culpability levels is the presence or the absence of a positive desire to cause the result. Purpose requires a culpability beyond the knowledge of a result's near certainty. In the broader sense, this distinction divides the vague notion of callousness from the more offensive maliciousness or viciousness. The latter may simply be an aggressively ruthless form of the former. Lastly, after this knowingly and versus recklessly, a person acts knowingly with respect to a result if he or she is nearly certain that his or her conduct will cause the result. If he or she is aware only of a substantial risk, he or she acts recklessly with respect to the result. Narrow distinction between knowledge and recklessness lies in the degree of risk. Practically certain versus substantial risk, of which the defendant is aware. The distinction between recklessness and the two higher levels of culpability is that we tend to scold a reckless person for being careless, while we condemn an offender who falls within one of the higher culpability categories for intentional conduct. Purpose as an independent of likelihood, while knowing and reckless culpability focus on the likelihood of causing the result, practically certain versus substantial risk purposeful culpability pays no regard to the likelihood of the result. This characteristic of the purpose requirement reflects on the instinct that trying to cause the harm, whatever the likelihood, is more condemnable than acting with the belief that the harm will or might result without desiring it. The practical effect of this is that the reckless conduct, as manifested in risk-taking, can be elevated to purposeful conduct if the defendant hopes that the risk will come to fruition. This characteristic of purpose also illustrates how specially demanding it is. A requirement of a particular belief is something a jury might logically deduce from other facts. The defendants must have known the certainty or the risk of harm if he or she knew this fact or that. A purpose requirement requires the jury to determine the defendant's object or goal or somewhat more complex psychological state. To find this, a jury may have to dig deeper into the defendant's psyche and his or her general desires and motivations to reach a conclusion. If a jury is conscientious in adhering to the proof beyond a reasonable doubt, standard constitutionally required for offense elements, this may be a difficult conclusion to reach. What is the difference between recklessly and negligently? A person acts recklessly with respect to a result if he or she consciously disregards the substantial risk that his or her conduct will cause the result. He or she acts only negligently if he or she is unaware of the substantial risk but should have perceived it. The recklessness issue focuses not on whether he or she should have being aware of the risk, but instead on whether he or she was in fact aware. Recklessness as conscious wrongdoing. The narrow distinction between recklessness and negligence lies in the defendant's awareness of risk. The difference between negligence and the three higher levels of culpability is one of the most critical distinctions in the United States criminal law. A person who acts purposely, knowingly, or recklessly is aware of the circumstances that make his or her conduct criminal, or is aware that harmful consequences may result, and is therefore both blameworthy and deterrable. A defendant who acts negligently, in contrast, is unaware of the circumstances or consequences, and therefore some writers argue is neither blameworthy nor deterrable. Although writers disagree over whether negligence ought to be adequate to support criminal liability, it is agreed that negligence represents a lower level of culpability than and is qualitatively different from recklessness, and that the negligent person fails to recognize rather than consciously disregard the risk. For this reason, recklessness is considered the norm for criminal culpability, while negligence typically is punished in American jurisdictions only in exceptional situations, such as where death is caused. What is the difference between negligently versus faultlessly? Liability imposed for faultless conduct is termed absolute or strict liability. The distinction between negligence and strict liability focuses on whether the defendant's unawareness of the risk constituted a failure to meet the standard of the reasonable person. The broader distinction between the four categories of culpability and faultlessness is the distinction between a blameworthy and a blameless defendant. The objections to strict liability stem from an understandable reluctance to punish conduct that is not unreasonable. Concurrence requirement. When an offense definition requires a particular level of culpability for a particular element, it means that the required culpability for the element must exist at the time of the conduct constituting the offense. This concurrence requirement, as it is called, reflects the law's interest in judging the culpability of the act rather than the general character of the defendant. The required concurrence between act and culpability is implicit in the Model Penal Code's culpability definitions. It is neither necessary nor sufficient that culpability exists at the later time of the result of the conduct. Changing one's mind after setting a bomb, for example, does not bear liability for deaths caused by the blast, even if the intent to kill no longer exists at the time the bomb explodes or the victims die. The next big part is the doctrines of imputation. Typically, a person is liable for an offense if and only if the person satisfies the elements of an offense definition. There are two exceptions to this rule. First, a person may be liable for an offense even though he or she does not satisfy all offense elements if a rule or doctrine imputes the missing element. Second, a person may escape liability even though the person does satisfy the elements of an offense, if he or she satisfies the conditions of a general defense. Imputation principles as independent of offense. A legislature conceivably could include inculpatory and exculpatory exceptions to the offense paradigm within the offense definition. For example, Tennessee defines the offense of arson to include not only setting the fire, but also assisting another in doing so. More typically, however, doctrines of imputation, such as complicity, are drafted in a form of independent of offense definitions, a form that applies to all offenses. This approach harnesses the benefits of drafting efficiency as well as encouraging conceptual clarity. Like general defenses such as insanity, duress, and law enforcement authority, which are separate and apart from any offense definition, the rules of imputation represents principles of liability and of any single offense. An additional point of similarity with general defenses arises because of the doctrines of imputation. At least theoretically can impute a required element for any offense defined in the code's special part. Some doctrines of imputation may tend to apply most frequently to certain recurring factual situations. Transferred intent, for example, appears most commonly in bad aim murders cases. This is, however, a factual rather than a theoretical limitation. Doctrines imputing objective elements. American criminal law permits the imputation of both objective and culpability elements of an offense. The most obvious and common instances of imputing objective elements are found in the rules governing complicity, but complicity is only one of several doctrines that impose liability even though the person does not satisfy the objective elements of an offense. Where a person exercises control over an innocent or irresponsible person, the latter's satisfaction of the objective elements of an offense may be imputed to the former as instance of causing crime by an innocent. Similarly, various statutory and judicial presumptions permit the imposition of liability, even though the evidence adduced at trial would not establish the objective elements of the offense. Finally, rules imposing liability for a person's omission, even when the offense charged is defined only in terms of affirmative conduct, also may be viewed as instances of imputed conduct. Next part is complicity. Complicity is not an offense in itself, as are conspiracy and solicitation, for example. Rather, it is a theory of liability, by which an accomplice is held liable for an offense committed by the perpetrator. An offense definition typically requires that the person have performed certain conduct, but a person may be held liable for the offense although the person has not performed the required conduct if he or she is legally accountable for the actual perpetrator's conduct. At common law, complicity liability required that the accomplice assist the perpetrator in committing the offense. The assistance need not to be necessary for successful commission of the offense, nor need it to be substantial. Indeed, the accomplice need not assist in physical sense at all. Encouragement is recognized as a form of assistance. On the other hand, the Model Penal Code extends complicity liability to those instances in which the person simply agrees or attempts to aid the principal. Actual assistance, even in the form of psychological assistance through encouragement, is not required. The drafters intended that what constitutes an adequate attempt to aid will be determined by reference to the definition of the general inchoate offenses to attempt. Okay, after this, let's look at the corporate criminal liability or liability of legal persons. Because an organization can neither act nor think except through its agents and officers, it cannot satisfy the elements of an offense except through imputation. Thus, if criminal liability for organizations is to be provided, the criminal law must specify the rules for imputation of conduct and culpability to an organization. Under current American law, two forms of liability against organizations are common and accepted. First, liability is permitted where the offense consists of an omission to perform a specific duty imposed on the organization by law. This requires no imputation and no application of special rules for liability, because liability follows directly from an organization's failure to perform the affirmative duty placed on it by relevant legislation. Most jurisdictions also permit organization criminal liability for standard offenses based on an affirmative act of an agent or an omission of an agent to perform a legal duty not expressly imposed on the organization. Most jurisdictions permit corporate liability for serious offenses under certain circumstances, even for offenses carrying a significant penalty and requiring culpability. In State v. Christie Pontiac GMC Inc., for example, a salesman for the Christie Pontiac car dealership swindled two customers out of cash rebates and kept the money for the corporation. Under the rules of organizational liability used in Christie, the criminal acts of corporations' agents are imputed to the corporation if they are, first, performed within the scope of employment, second, in furtherance of the interest of the corporation, and third, authorized, tolerated, or ratified by corporate management. Because the corporation received the swindled funds, and the conduct was ratified, if not authorized by the corporation's president, the corporation was held liable for the employee's criminal act. Some jurisdictions follow the Model Penal Code in extending liability beyond conduct authorized or ratified by corporate management to offense conduct, recklessly tolerated by such actors. This doctrine seeks to prevent management from simply turning blind eye to violations because the violations further the corporate interest. Most jurisdictions provide defense where upper management exercise due diligence to prevent commission of the offense. Next, inchoate liability. American criminal law recognizes three general inchoate offenses: attempt, conspiracy, and solicitation, where a person attempts, conspires with another, or solicits another to commit an offense, but the offense is never committed. The person nonetheless may be liable for one of these inchoate offenses. Solicitation is in Hungary called preparation, or very similar to it. Okay, first let's look at attempt. At some point in the chain of events, from thinking about committing an offense to completing it, a person's conduct becomes criminal. This point typically is described as the moment at which mere preparation becomes a criminal attempt. Defining this point is an important part of attempt liability because it demarcates both when a person becomes criminally liable and when authorities lawfully may intervene. Attempt is significantly different from other offenses under American law because even after this point is reached and all elements of the attempt are satisfied, a person typically may escape liability if he or she voluntarily and completely renounces the attempt. Absent such renunciation, the failure to complete an offense only prevents liability for offense. It does not relieve the person from liability for the attempt. The most common American objective requirement for attempt is the person to take a substantial step toward commission for the offense, rather than focusing on how close to the end of the chain the person has come to the approach of the proximity test used at common law. This approach focuses on how far from the beginning of the chain the person has gone. The code gives 7 illustrations of what shall not be held liable insufficient as a matter of law to constitute a substantial step. Current American law commonly elevates the culpability required for an offense when it is charged in its inchoate form. Thus, although recklessness with respect to causing injury may be sufficient for aggravated assault, in many jurisdictions, attempted aggravated assault may require purpose or knowing with regard to causing injury. There is disagreement over whether this is wise policy. It may well be that attempts should require proof of a purpose to complete the conduct constituting the offense, but that the normal culpability levels for the offense elements ought not to be elevated. Conspiracy. Conspiracy typically requires an agreement between two or more conspirators that at least one of them will commit a substantive offense. The agreement need not to be an act in a strict sense, speaking, writing, or nodding can signal agreement, but one also can agree through silence where under the circumstances or custom silence is meant and understood to mean positive agreement. At common law and currently in some jurisdictions without modern codes, the agreement requirement is taken to require actual agreement on both sides and actual meeting of the minds. Thus, for the person to be liable for conspiracy, the other conspirator must actually be agreeing, not just pretending to agree, as an undercover police officer would, for example. Modern American courts have adopted a unilateral agreement requirement which permits conspiracy liability as long as the person agrees with another person without regard for whether the other person is returning to the agreement. Perhaps because conspiracy agreements requirement is so slim a conduct requirement, an overact is typically also required of one of the conspirators in furtherance of the agreement in order to sustain a conviction. Solicitation. Solicitation is essentially an attempt to commit conspiracy by encouraging or requesting another person to do what would constitute an offense or an attempt. As with conspiracy, the offense focuses on the person's subjective view of the world. Solicitation need not to be successfully communicated. It is sufficient that the solicitor's conduct was designed to effect such communication. Unlike attempt, where the person's conduct may be ambiguous with respect to its criminal purpose, the solicitation offense includes no special requirement that the person's conduct strongly corroborate his or her criminal purpose. Okay, after these general rules of criminal liability, let's look at general defenses. In casual language, anything that prevents conviction of a person is called a defense. But this term includes doctrines that are very different from one another. The legal doctrines that were referred to as defenses typically are of 5 sorts: absent element defenses of offenses, modifications, justifications, excuses, or non-exculpatory defenses. Types of defenses. First, absent element defenses. Some doctrines that are called defenses are nothing more than absence of required offense elements. If a person takes an umbrella, believing to be his or her own, he or she may claim a mistake defense, but this defense derives not from a special defense doctrine, but mistake as to ownership, but rather from the elements of the theft on offense itself. The definition of theft includes a requirement that the person know that the property taken is owned by another. If a person mistakenly believes that the umbrella taken is his or her own, he or she does not satisfy the required culpability element of knowledge that it belongs to another. Such mistake defense is called an absent element defense because it derives from the inability of the state to prove a required element. The person is claiming that the prosecution cannot prove all the elements of the offense. It is within accepted casual usage to call such claims defenses, but they are simply another way of talking about requirements of an offense definition. Offense modification defenses are the second group. Some defenses are indeed independent of the offense, some elements, but in fact concern criminalization issues closely related to the definition of the offense. They typically refine or qualify the definition of a particular offense or group of offenses. Voluntary renunciation, for example, can provide a defense to inchoate offenses like attempt or conspiracy. Consent is recognized as a defense to some kinds of assault. Such a consent defense helps define what they mean by the offense of assault, just as renunciation helps refine the definition of inchoate offenses. Indeed, assault frequently is defined as unconsented to touching. That is, the absence of consent sometimes is included as an element of the offense. As the practice illustrates, the difference between absent elements defenses and offenses modification defenses is one of more form than of substance. An offense modification defense can as easily be drafted as negative element of the offense, for each defines in part what the offense is not. Next are justifications. Justification defenses, such as lesser evils, self-defense, and law enforcement authority, exculpate on the theory that persons' otherwise criminal conduct avoided greater harm or evil. That is, although a person satisfies the elements of an offense, his or her offense is tolerated or even encouraged because it does not cause a net societal harm. A person who burns a firebreak on another's son may thereby commit arson, but also may have justification defense of lesser evils, because by the burning the person saves innocent lives threatened by the fire. The commonly believed doctrines of justification are the lesser evils defense, the defense for forced defenses or self-defense, defense of others, defense of property, and defense of habitation, and the public authority defenses of law enforcement authority, authority to maintain order and safety, parental authority, benevolent custodial authority, medical authority, suicide judicial authority, military authority, and general public authority. Next, excuses. Excuse defenses such as insanity and duress exculpate under different theory. The defendant has admittedly acted improperly, has caused a net societal harm or evil, but the defendant is excused because he or she cannot properly be held responsible for his or her offense conduct. Note the difference in focus between justifications and excuses. A defendant's conduct is justified, a defendant is excused. Excuses are of two sorts: disability excuses, which include insanity, involuntary intoxication, duress, and immaturity, and mistake excuses, which include mistake about justification, reliance on an official misstatement of law, and unreliable law. A final group is the non-exculpatory defenses. A final group of general defenses does not exculpate a person, but does provide an exemption from liability, even if the person's conduct is criminal and unjustified, and the person is fully responsible for it. Such non-exculpatory defenses are made available because each furthers important societal interest. Thus, diplomatic immunity may provide a defense without regard to the guilt or innocence of the person, because by doing so, a country's diplomats are protected from interference when abroad, and diplomatic communications among nations can be established and maintained. Other common non-exculpatory defenses in American courts include statutes of time limitation, judicial, legislative, and executive immunities, and immunity after compelled testimony or pursuant to plea agreement. Further, many constitutional principles function as non-exculpatory defenses, such as the double jeopardy clause and the exclusionary rule, as well as the legality principle. Thank you for your attention.